Attorney General.
Thank you very much, Honourable Speaker. Just before the break, I was talking about a Supreme Court of Canada decision where the court was taking the sharp edges off the traditional tort of defamation, the cause of action, the ability to bring something to court, and it was in relation to Rafe Mair and comments he had made as an opinion columnist on the radio, and the court carving out an exception for opinion columnists. Another really important case where the court kind of articulated this new approach to defamation is a case called Grant versus Torstar Corporation. Torstar Corporation, at the time the owner of the Toronto Star. And it was in relation to a newspaper article that was published in that paper. And the court, instead of an opinion piece, a year later was now grappling with a news report. And in the first part of my speech, I talked about how journalists are often subject to defamation threats and actions, and they're less successful than other actors when they're sued for defamation. And the court, trying to deal with this, trying to reconcile the charter values of free expression with the tort of defamation that was not set up to protect free expression, was in fact set up, in my opinion, to repress free expression, to protect people with the ability to bring court actions. And the court, recognizing this to some degree in this decision, when they take the, as I say, the rough edges off it. So the background on this one is that Grant and his company owned a piece of land. There was a proposed private golf course that they wanted to do, and it bordered on Grant's lakefront estate. And the Toronto Star reporter went out and, of course, heard the opinions of local residents, as you would expect about something like this. They were critical of the environmental impact of the development. They were critical of they were suspicious that Mr. Grant was working behind the scenes with politicians to exert political influence to get the thing approved. And the article, the offensive speech to the plaintiff was, the article quoted a neighbor who said that, quote, everyone thinks it's a done deal, unquote, because of Grant's influence, that he was improperly influencing a process of review of this golf course proposal. And so the reporter got this quote from the neighbor and reported on these concerns about improper influence, tried to contact Grant for comment about this. Grant chose not to provide comment, and the article was published with these concerns in it. And Mr. Grant responded to the article by suing the Toronto Star for defamatory speech. And one of the defenses that was used by the reporter, by the Toronto Star, was the defense of truth and the defense of fair comment. And the issue was, obviously, that it was quite difficult to prove truth around this. And in terms of fair comment, it's a restricted defense. And the jury rejected those defenses. The journalist at trial tried to say that reporters have should, when they go to someone for comment, and the person chooses not to comment, and they have these allegations, that they should have the ability to report on that kind of thing without being sued for defamation. So the court's got to grapple with this, because at trial, under the traditional defamation action, this reporter definitely defamed Mr. Grant. He had no evidence that Mr. Grant had improperly influenced, other than the neighbor's suspicions. Reported this in the paper. It was published, made people think less of Mr. Grant, satisfied all the elements of the tort. But at the end of the day, the reporter says, look, these allegations are being made. I had an obligation to report it. I don't feel one way or another about Mr. Grant. This is just something that I needed to do. And just because he doesn't talk doesn't mean I shouldn't be able to do it. So the court's trying to figure out, well, what are we supposed to do here? Because he made out all the elements of the tort, the plaintiff did, but maybe the reporter has a point here. Maybe Toronto Star has a point here. And that is actually what they conclude in dismissing the case and saying, no, there are no damages due here. And Toronto Star Corporation shouldn't have to pay Mr. Grant any money. So the majority of the court says, we want to modify this traditional law of defamation to make an exception for reporters. We want to provide greater protection for communications on matters of public interest. And in this bill, when I start to go through it, you'll see that it talks about matters of public interest. So 2009 is when the court first starts to talk about matters of public interest. And there's been a bunch of cases since then, so it's very fleshed out. And the bill incorporates that public interest test into the bill. It doesn't change it at all. So the court says with no uncertainty, this is from the headnote, quote, the current law with respect to statements that are reliable and important to public debate does not give adequate weight to the constitutional value of free expression. And so they bring in Section 2B of the Charter of Rights and Freedoms. Even though it shouldn't apply, it's a newspaper company and a private citizen, the Charter shouldn't apply. It only applies to government action, but they say there are these values, democratic governance, getting at the truth, that applies here, so we're going to modify it. The court again talks about, and there are certain terms, Mr. Speaker, that you only see in judgments. One of them is this one in defamation cases, freewheeling debate. And the court talks about this freewheeling debate on matters of public interest, that it's the court's responsibility to encourage that and to safeguard it. And that while the law must protect reputation, it's gone too far, that the current level of protection is not justifiable. That's again from the head note of the case. And because it provides absolutely no protection, it provided absolutely no protection for statements on matters of public interest. And I talked about what the court in the other judgment talked about, the rough trade of exchange and public debate and so on. The court comes back to that idea in more detail in Grant, and they say, look, we don't want to insist that you have to have court established certainty in relation to matters of public interest. Mr. Speaker, I just noticed the red light. I thought I was designated speaker on this for a couple hours.
I understand you're the designated speaker?
Yes, Mr. Speaker.
So we will ignore the red light.
Thank you very much. So the court says, look, to require someone to be like a judge and have all the evidence and proof to a court standard in reporting on a matter of public interest will have the effect not only of preventing the communication of facts that a reasonable person would think were reliable, but also would inhibit political discourse, would inhibit a reporter from reporting, would result in what the court talked about in the other decision of investigative stories being spiked, never reported. And as the court noted, less offensive material coming in to fill the space. The public might not notice the effect of this, but the effect is very real. And the reason, Honourable Speaker, that I'm going into some detail on this is to provide some context, because there is a very real objection to legislation like the kind that we're bringing forward to say, look, the court already has protections around defamation, around free speech, and so on, and so this legislation is not necessary. But it's really important to understand these cases to understand why this legislation is actually necessary, to give effect to some of the things that the court is saying about the tort of defamation. When the court looked at what was happening around the world and welcome, Honourable Speaker, to the chair. It's nice to see you up there. Congratulations. When the court looked around the world at what was happening in other common law democracies about defamation law, the court said, look, we see what's happening in other places. They're changing their laws to allow more free expression and to restrict the use of the defamation tort. That favors us replacing the current Canadian law with a rule that gives greater scope to freedom of expression while offering adequate protection of reputation, because the court says a right to free expression does not confer a license to ruin someone's reputation. So one of the ways that the court comes to squaring this circle is to say, we will create a new defense for publishers. They can escape liability if they can establish that they acted responsibly in publishing something and attempting to verify the information, to go to the person, do you have a comment on this? Do you have some information to share with our readers? We have this allegation. What do you say about it? And giving them a chance to respond, and that a publisher that gives someone a chance to respond and publishes responsibly could have a defense to a traditional defamation action. And they modify the law to allow that kind of defense to go forward, which they felt was very important to protect journalists. Now, the defendant doesn't just have to show that they gave a chance to respond, but they have to show that the publication was responsible, that they were diligent in what they tried to do. It wasn't just like, oh, you know, we sent a fax and nobody responded. We sent an email and nobody responded. We knocked on the door and nobody answered. They have to be diligent in trying to verify the allegations. And also, the court needs to consider the subject matter of the publication as a whole. That the defamatory statements can't be considered by themselves. They need to be considered, is this a newspaper, or was this a one-time publication exclusively for the purpose of attacking the person? And then the defendant must show that the subject matter was one that invites public attention. And so there are a number of different tests that the defendant also has to raise which talk about the seriousness of the allegation, the public importance of the matter, the urgency of the matter, the status and reliability of the source of the information, whether the plaintiff's side of the story was sought and accurately reported, whether the inclusion of the defamatory statement was justifiable, whether the defamatory statement's public interest and the fact that it was made rather than its truth, and any other relevant circumstances. So, Honourable Speaker, this is the point, is that is all on the defendant. All the plaintiff has to do is say, this was published, this caused people to think less of me, and I am entitled to damages, and then they sit down, and then it's all on the defendant to prove all of these other things, and prove them on a balance of probabilities. And only by proving those things and addressing these circumstances can the defendant defend themselves against the lawsuit that's been started against them. And it goes all the way to the final decision. And so when you consider the fact that this went all the way to the Supreme Court of Canada, the Torstar media organization had to go through 3 levels of court, a full trial, and prove all of these things. And all that Mr. Grant had to do was prove that somebody published something that made him appear to be less reputable to other members of the public. It's very unbalanced. And it's that lack of balance that you can file the claim, that the test is set up like this, that all the work has to be done by the defendant, that leads the tort of defamation to be particularly high risk to being abused, to stop someone from talking about something that you would like them to stop talking about by filing a lawsuit. So that takes us to 2009. In Ontario, the Supreme Court of Canada cases came down. People were talking about them. Those defenses started to roll out. People were using them in court. And yet still there was a sense that the tort of defamation was being abused by people with means, people who were able to threaten lawsuits to stop someone from talking about something that they don't like them to talk about, and so they just threaten a lawsuit to stop them from talking about it because all the advantages are conferred to the plaintiff in this tort. And so Ontario commissioned the Morin review of defamation law, the Morin panel, and I'm indebted to Jeremy Schrag, who's a lawyer in British Columbia, who wrote a paper on this, detailing some of the background on the Ontario Morin panel. And in 2010, they released their recommendations to the public about how can we fix this? How can we address this issue, this imbalance between the plaintiff and the defendant, and the fact that this appears to be inhibiting free speech, appears to be preventing people from the freewheeling, rough trade of public debate about the issues that matter. So they released the report in 2010. They had a bunch of submissions from individuals and organizations, and at the end of the day, this panel that was independent of the Ontario government, quote, was persuaded that threats of lawsuits for speaking out on matters of public interest, combined with a number of actual lawsuits, deter significant numbers of people from participating in discussions on such matters. And they said that there was a need, quote, for Ontario to enact legislation against the use of legal processes that affect people's ability or willingness to express views or take action on matters of public interest. So this is in 2010 in Ontario. A whole lot of water under the bridge since 2001, when BC introduced its first legislation to control the use of the law in this way, and it's 10 years later. And the Morin panel said there are a couple elements that we'll look for to make sure that a law that's brought in to deal with this type of use of the law or abuse of the law is reined in. They said we want to see that there's an expedited process, that things happen faster. So if you're sued for defamation, you can get in front of a judge faster, you can get a decision faster. You don't have to go through the whole trial to get a decision. We also want to see a reduction in the economic burden that these types of lawsuits place on defendants. There's any number of ways that the law could do that, but that's a factor that we would look for to see whether or not it's an effective law. And we also want to see economic disincentives to the filing of these lawsuits in the first place. We want to make sure that people are really committed to actually following through, that they are actually injured, that they actually have the desire to go ahead with this, and it's not just to stop someone from talking about something that makes the other person feel uncomfortable in relation to something they have an interest in, because we want to protect free speech. The report also recommended that there be a broad scope of protection keeping the recent Supreme Court of Canada, then recent Supreme Court of Canada decisions in mind that I've taken you through. Now, one of the key comments of the panel, it was relevant to the 2001 law that we had in BC, is they were pretty critical of the 2001 law, in particular that the 2001 law in BC required you to prove that the person who was suing you had a bad motive. They intended you harm by filing the lawsuit against you. It was a very difficult thing to do, to prove that. And the Morin panel said, as a result of that, that law is not as effective as it could have been. So we think that future laws should not rely on the motive of the plaintiff if we can avoid it. They said that, quote, judging the motive of a plaintiff is likely to be difficult and often impossible in an expedited proceeding. The effect that the action is likely to have on expression on matters of public interest should not require the judge to read anyone's mind and would be more readily supported by evidence. I'm paraphrasing that last bit. So they say, instead of looking to whether the person suing this person who's expressing themselves, instead of trying to figure out whether they're doing it for a bad purpose, why don't we just look and see what the effect of it is? Is it a matter of public importance? Is it stopping this person from talking about it? Is it interfering with the public hearing something that's an important communication about this matter of public interest? And so they set out a proposal around the procedure for identification and dismissal of these lawsuits at an early stage, not at the end of trial, which was the case before this law was introduced in Ontario. First, does the expression that is the subject of the lawsuit involve a communication on a matter of public interest? As I said, this is something the Supreme Court of Canada has considered, and many courts have since they did in Grant v. Torstar in 2009. If it's shown to be on a matter of public interest, then immediately the responsibility to provide proof to the court, the onus, should shift to the plaintiff, the person who's bringing the lawsuit. The plaintiff should have to show on the factual record that the plaintiff actually has a decent case. The plaintiff should have to show that there are grounds to believe that the defendant has no defense. So what the law should do is it should shift responsibility from the defendant to the plaintiff, the person who's bringing the lawsuit, which is the way it is in most personal injury actions and torts that are brought in front of the court, except in defamation. Defamation is one of the only torts where you see that the defendant has all the work to do, not the plaintiff. And then finally, if the plaintiff meets those tests, the court should consider, in all the circumstances, whether the action is for an insignificant harm, and yet it has a significant impact on free expression. So it may be that the court looks and says, okay, you've got a good case, you're likely to be able to prove it, the other person probably doesn't have a defense, but even if you're successful, this is such an insignificant harm that you suffered. It's a very small case, but the impact that you're going to have on free expression is significant. So even though you've got a case that could succeed and you're going to get an award of $500, we're going to say the impact that this has on free expression is too much. And so we're going to say that person should be able to make the remarks that they're making for the purposes of furthering public discussion and debate. The Morin panel is pretty clear. They trust judges to ensure that truly harmful or lawless behavior is not encouraged in the name of public participation. And the courts have made very clear that there's a whole category of lawless behavior or harmful behavior that is not protected in any defamation defense. And I'll go into those in some detail in terms of the different kinds of harmful communications as I talk about the bill. The Morin panel also said, look, we need to make this less costly for people who are being sued. Short deadlines for the documents to be served and responded to an expedited hearing. And this is important because you're going to see it again in the bill. You're going to see all of this. The reason why I'm talking about the Morin panel is because this bill is based on what happened in Ontario, Ontario's bill, and I'll go into why we did that. And Ontario's bill was based on the Morin panel. Short deadlines for replies, expedited hearing, and the suspension of steps in the underlying action. And I'll go into some detail on that in the bill. But what it does is it puts a lot of pressure on someone, because if they want to stop someone from speaking, they have to suspend the steps that they're taking in the other process that might be the subject of the person's expression. It sounds complicated, but I'm going to go into it in a second and explain it a little bit. There should also be discretion for the courts to award costs to successful defendants. the court should be able to dismiss with prejudice. There should be some way for the court to recognize if, in fact, it's obvious that someone brought a lawsuit for a bad purpose. There should be some way for the court to support the defendant, to recognize that the defendant was unfairly brought to court. And there should be damages available. The court shouldn't just be able to say, this was a really bad lawsuit that never should have been brought, but actually, we think this guy who you sued should get a bunch of money from you because the lawsuit you brought was so bad, was so poor, was motivated by such malice, that we're actually going to recognize that by making you pay this individual beyond just their costs, but additional costs as well. What was happening in BC at that time? Well, actually, most of what happened in BC was before 2010 when Ontario was doing all of that. In 2001, there was an anti-SLAPP bill introduced in the last months of the then NDP government by Attorney General Andrew Petter. He provided quite a detailed set of reasons for bringing this groundbreaking legislation forward. I believe it was the first anti-SLAPP bill in Canada when he brought it forward at the time. He talked about the reasons why they brought it forward. Again, and history repeats itself, the Union of BC Municipalities had asked for this kind of legislation to be in place. Again, the UBCM has asked for this legislation to be in place. One of the reasons why it's in front of the House today. There was concern, he went through concern about the fact that it wasn't necessarily the number of cases that are brought, but many cases that don't even get to court aren't even filed. Simply a threat of defamation action is enough to stop people from speaking, a concern that motivated the legislation in 2001, and it motivates it again here today in this place. He noted that in other jurisdictions that they were moving, at the time, 13 U.S. states that have such legislation, the number is higher now, but that they had moved to address this issue in their jurisdictions. And he said they believe it or not, that people should be able to stand up and speak on an issue that concerns them, to advocate in favor of a public position on issues without being the subject of litigation, without having to go and consult lawyers, or if indeed they have to consult lawyers, without having to incur the full cost that litigation can impose upon them because there is no protection for their participation. Sounds very similar to the concerns of the Supreme Court of Canada many years later, and also Ontario's concerns that resulted in the Morin panel and the recommendations there. He talked about the concern related to balance of protecting reputation and protecting free speech, the same balance that we're trying to strike with this legislation. And he also talked about the ability to get a quick dismissal of a claim and to seek costs if someone brings a lawsuit like this against you, that it shouldn't be a huge financial burden that drags for years. There should be an expedited process. But, Honourable Speaker, there is something that was different, and a significant difference. And that is something that I addressed a little bit already, which is that the 2001 bill required the court to reach into the mind of the person who was bringing the lawsuit to find out if they were bringing the lawsuit for an improper purpose. It had to show that, quote, a principal purpose for which the proceeding or claim was brought or maintained is an improper purpose. And that's a very difficult thing to prove. And it was certainly acknowledged at the time by Dr. Petter, now Dr. Petter, that it is very difficult to prove motive, and it is something that ultimately has been abandoned in other jurisdictions going forward to make sure that that their legislation is effective. But as I say at the time, this was quite groundbreaking legislation. The goal of the legislation in 2001 is the same as the goal of the legislation now. Dr. Petter said, quote, "It's about time that people in BC have some legislative assurance and a tool that says to them, yes, if you stand up, if you are one of those in our society who's prepared to stand up and say controversial things and take on the issues, the legislature is going to protect you from others who might want to prevent you from doing that." And so that remains totally unchanged. Now, at the time, of course, in the opposition, Jeff Plant, then the critic for the Attorney General, later to be the Attorney General who actually repealed the legislation. And he objected to a number of points related to legislation. His main point, he had two. One is, paraphrasing, there is no particular issue. You haven't really proven that there's an issue that needs to be addressed. And even if there is an issue, even if I assume that you're right that there is an issue, the court has a bunch of mechanisms in place, even in 2001, even before Grant v. Torstar, even before the Rafe Mayer case. He believed that the court had a number of mechanisms to deal with these kinds of things, namely Rule 18A, and other mechanisms. And so rather than paraphrase, to be fair to Mr. Plant, I'll read a little bit from his speech. Quote, "Our rights and freedoms are of no value if a person is denied or delayed access to a court of competent jurisdiction to vindicate them. Yet that's what this bill does. It does it deliberately. It deliberately seeks out to deny and delay access to the courts. It sends a message to those whose rights are infringed. Don't bother with a lawsuit. The courts are not there to help you." Quote, "Any bill presented to any legislature should satisfy a series of tests. The first is this: is there some pressing and urgent problem that needs to be addressed?" Later on, he says, he goes through a number of examples, there is no problem. Among other things, he cites that there's only one case that he could find that specifically mentioned strategic litigation against public participation. He continues to say, Rules 18 and 18A in the court, these are rules of court that allow summary power for courts to dismiss claims. Rule 18 and 18A provide the court with a summary power to dismiss unmeritorious cases after hearing some evidence in an application, on an affidavit, in an application that can be made summarily and can be dealt with expeditiously. Quote, "It's hard to see evidence of the problem, and secondly, in any event, if there's a problem, the law already contains the tools for responding to the problem." So there was a lively debate on the issues between Mr. Plant and Dr. Petter, both of whom have gone on out into public life to participate on many issues of public importance and to debate those issues. The interesting thing is that to some degree, both were proven right. Certainly Dr. Petter was vindicated in the sense that the court recognized on multiple occasions that people's rights of free expression were being infringed by defamation actions, that this was a serious problem, that this was a big problem, that the court needed to intervene in and create new processes, new defenses for people to avoid their free expression, including journalists and commentators, to prevent their free expression from being interfered with. So he was vindicated in that sense. I would say Mr. Plant vindicated in the sense that the court itself, in the absence of legislative action, because this bill was ultimately repealed, started to carve away at the defamation rules to allow free expression to continue. Where I think the two parted company that is still unresolved, and where I agree with Dr. Petter's approach and not Mr. Plant's approach, is whether or not there's a need for a process mechanism, a way to have the court be able to hear at a very early stage whether or not someone's free expression is being interfered with, and to deal with it as opposed to at the end of the trial after the defendant has been put through all these hoops of having to prove all these different things, and the plaintiff has only had to say, look, someone made me look bad in the eyes of other people. And that's where the big departure is between the two still today, as I say, both vindicated on some points, but where obviously, because we brought this bill forward, still agree with Dr. Petter, is that there is a need for us to have a process in place for early resolution of this to prevent undue interference with freedom of speech, entirely consistent with the Supreme Court of Canada's decisions and their dicta about Section 2B, the things that they've said in their cases about Section 2B, the free expression provisions, and actually supportive of providing the courts with the opportunity to do this. In 2001, the bill in BC was repealed. The anti-SLAPP bill was repealed by Mr. Plant, who was then the Attorney General. The only comments I could find on the record that he made about this, I'll read them for you so that you understand the reasoning for repealing it. Quote, "It was in a miscellaneous statutes bill that also repealed pay equity amendments to the Human Rights Code and repealed a program to protect property from redevelopment that was held for affordable housing for seniors." So it was quite a bill. But in any event, Mr. Plant read this in terms of explaining why the bill repealed the then act in BC. Quote, "Finally, this bill repeals the Protection of Public Participation Act that was brought into force in April 2001. That act was created with the idea of intending to help persons deal with unmeritorious lawsuits brought against them. In fact, the act was too broad, and it has the potential to cause considerable delays in the court system and in British Columbia if it is misused by persons who in turn want to cause delay and expense to plaintiffs who are entitled to bring legal proceedings in British Columbia. In my view and the view of the government, the existing rules of the Supreme Court are sufficient to protect parties from frivolous and vexatious lawsuits, and also to provide for remedies in the form of costs where appropriate to be awarded in appropriate circumstances. This bill contains a transitional clause they will protect the rights of anyone who has made use of the Protection of Public Participation Act during the period that it was enforced. And that's the sum total of the remarks about why the bill was repealed. A very brief restating of his argument that he made in opposition about why he didn't support the bill, that the existing rules were sufficient. In his defense, 6 years, 7 years, not that I spend a lot of time defending Mr. Plant, but in his defense, 6 years or 7 years before the Supreme Court of Canada issued its decisions in Grant v. Torstar and Rafe Mayer, 6 or 7 years before that, where the court said, yeah, actually there is a serious problem here. Yeah, actually we do need to deal with this. And he didn't have the benefit of that, but still I disagree with the fact that he repealed what was the necessary provision. Which brings us to the Act, Honourable Speaker. I know the members are shocked. I've finally gotten to the Act. This is really important because it's a short Act, right? There's not a lot of provisions in the bill, and it's hard to know why they're there or what it's about unless you know a little bit of the background. And I've been very pleased to have the time to be able to go in some detail into this and assist the members in understanding why we're bringing this forward. So the first section, the definition section, not the most exciting section of the Act. I'll come back to it to talk about administrative proceeding because it's very broad, and also expression is defined very broadly to include nonverbal communication. The only thing I'll pause on the definition section is to say that there are things that this definition will not capture, or at least it's not intended to capture, and because the courts have been very clear about what expression does and does not include, and it imports into it all of the case law about expression and what expression does and does not include. And I'll give you some examples of what expression does and does not include. First is expression that is beyond the pale of Section 2B of the Canadian Charter of Rights and Freedoms. An obvious example is hate speech, as defined in Section 319, sub 2 of the Criminal Code. The court's been very clear that that type of speech is not captured within Section 2B of the Charter under Section 2B and Section 1 of the Charter. An act of violence does not count as expression, which should seem obvious to everyone, but sometimes it's good to say it out loud because you never know quite what people are going to say about a bill outside the legislature who haven't had the benefit of this debate. A threat of violence is not expression. And any member who is curious, I'm happy to provide case citations for these kinds of things to explain why expression is, while defined broadly in the bill, under the case law in Canada, very clear about what it does and doesn't include. An act of violence or a threat of violence against others, not included. Now, you'll note that the definition of expression is not qualified by words such as lawful or appropriate expression or good expression or anything like that, because that's exactly what we want the court to determine. We're setting up the procedure for the court to determine whether the expression is in fact lawful, is in fact appropriate, is in fact protected. It's up to the court to determine that. So we didn't put in the definition because that's exactly what we want the court to determine. And it's necessary for the court to determine that. One of the Section 2, I talked about this a little bit in relation to the introduction. The Act applies in respect to proceedings commenced on or after May 15, 2018. In introducing the bill the first time, the bill applied to all defamation actions that are currently underway. I know this will be of some concern to people who, thank you very much, some concern from people who are currently participating in defamation actions, whether willingly or unwillingly, who may have been hopeful that this bill would apply to them. I will note that the intention here is to provide people with notice that, in fact, the rules have changed. The reason why we have the date of effect being May 15, 2018 and not royal assent is we don't want a bunch of people running down to the court registry and filing defamation actions to try to get them in before the date of effect. We want to make sure that people have noticed the rules are going to change and conduct themselves accordingly. But prior to this bill being introduced, people made decisions about whether or not to go to court, how to conduct offenses, and so on, and we didn't want to have undue interference with that. And I wanted to provide a little bit of background on that. Section 3, the background of this one, which talks about qualified privilege, it sounds really technical, if an oral or written communication on a matter of public interest between persons who have a direct interest in the matter has qualified privilege, the communication is qualified privilege regardless of whether the communication is witnessed or reported by the media or other persons. Like, what does that mean? It has some very significance for people who may be sued for defamation. So one defense, if you're sued for defamation, is called qualified privilege. And that can be communication by and to persons who share an interest in the matter being communicated. But if somebody else hears that communication and reports on it, then you lose that defense. So you're talking to some people that have a direct interest in the matter, you're talking about it, you definitely have the defense of qualified privilege. A journalist hears it, overhears it, and reports on it, you lose the defense. And so what this does, it doesn't change the rule of qualified privilege, it doesn't change anything related to that, but what it does do is it allows for reporters to do what they do, which is a report, without jeopardizing somebody's ability to raise a defense of qualified privilege. It is not a change to the law respecting qualified privilege generally. Section 4, this is the heart of the Act. It doesn't seem like a whole lot. It's 2 subsections, but this is the key of it. The purpose of the Act is to protect expression on matters of public interest. And you'll see here that it doesn't talk at all about, as the 2001 bill did, the need to inquire into the motivation of the person who filed the lawsuit. The Act, under this application section, allows the court to balance the effect of the expression on the harm suffered from the plaintiff in terms of the importance of the expression. It's exactly what I was talking about in the Supreme Court of Canada, how they were trying to balance people have a right to personal integrity under the Charter, they have the right to their reputation, and people also have the right to free expression. How do we do that balancing exercise? And this application to court allows for the court to do the balancing. It doesn't try to do the balancing for the court. It says, is this a matter relating to public interest? And then it goes into why it may or may not be subject to this protection. So there's 2 subsections, as I said. Section 4, sub 1, talks about matters of speech that are of the public interest. As I said, that is something the Supreme Court of Canada has considered in some detail. Importantly for this bill, in the pendency of the time from when we first introduced this bill to today, the Ontario Court of Appeal released a decision where they considered the Ontario bill, and they went through it in some detail, and they said, they made lots of comments about the Ontario bill, and it has a lot of relationship to our bill because our bill is based on the Ontario bill. So members who are particularly interested in this, they would be well advised to check out the Ontario Court of Appeal decision 1704604 Ontario Limited versus Point Protection Association. You can guess who was bringing the defamation action and who was alleging a slap in that confrontation. And your imaginings would probably be correct. It was the Point Protection Association that was accused of defaming 1704604 Ontario Limited. So the court in the Ontario Court of Appeal said public interest should be broad. They imported the whole jurisprudence from the Supreme Court of Canada around public interest. Potential subject matter is totally wide-ranging. It could be politics, it could be science and the arts, it could be the environment, it could be religion, it could be morality. There's not a limit to the number of topics or subjects that are matters of public interest. The court, though, did recognize the limit the Supreme Court put on matters of public interest, which that it does not extend to matters of mere curiosity or prurient interest, in which the person concerned has a reasonable expectation of privacy. So there is a limit on what is a matter of public interest for certain. Section 4 sub 2, if you make the public interest test and so on, it's important to recognize that 4 sub 2 is not an alternative to trial, it's not a summary judgment, it's a judicial screening, it's a triage process, the Court of Appeal said in Ontario, designed to eliminate certain claims at an early stage of the process. And so it talks about, and it's probably worth going through it, 4 sub 2, if the applicant satisfies the court that the proceeding arises from an expression referred to in subsection 1, that is a matter of public interest. The court must make a dismissal order unless the respondent, that's the person who brought the lawsuit in the first place, the person who brought the lawsuit in the first place has to satisfy the court that, first of all, A, there are grounds to believe that the proceeding has merit. My lawsuit is a good one. And the second is that the defendant, or the applicant, has no valid defense in the proceeding. Not only is my lawsuit a good one, this guy's got no defense. And then secondly, that the harm likely to have been or that will be suffered by the respondent as a result of the expression is serious enough that the public interest in continuing the proceeding outweighs the public interest in protecting the expression. And that's the balancing test. I've got a good case, this guy's got no defense, and the subject matter is not so serious and not so important that it outweighs my right to protect my reputation. All of that, you'll note, the burden is on the person bringing the lawsuit to prove these things. It is no longer on the defendant or the person being sued to prove these things. And that shift in the onus or the responsibility to show that to the court is critically important. Now, the term grounds to believe, what does that mean? It should be understood as reasonable grounds to believe, according to the Ontario Court of Appeal, with which we agree that is the intent. The plaintiff, the person who's suing somebody else, does not have to satisfy the court that it would win, but only that there's reason to believe, or there's grounds to believe, that the lawsuit has merit. And there's also reasons to believe that the defendant has no defense. This isn't the case itself. You just have to show that there's a reason to believe these things. And there's a reason for separating out that the case has substantial merit and that there's no valid defense. In defamation, there's a big difference between proving that somebody said something about you that lowered your reputation in the community and the defenses that are available to someone who's being sued. There's a big departure between these two. And so they're separated out here in the bill as well. So for example, a defendant can say it's true, or I have the defense of qualified privilege, or I have the defense from Grant v. Torstar in relation to responsible communication for journalists, or I have the defense from the Rafe Mayer case in terms of this is my opinion on the facts. And I have a right to my opinion, and to express my opinion, I reasonably hold that opinion. And so all these different defenses, the person who's bringing the lawsuit has to show that the person who's being sued has no defense, and there's no way to justify what they did. I would definitely recommend to members who are particularly interested in this a read of the Ontario Court of Appeal decision. I'll truncate my remarks about the case a little bit there, but they go into some detail in terms of judicial analysis of a bill that in many respects is almost identical to British Columbia's. Section 5, no further steps. This is a big deal. Remember when I talked in the Morin panel and they said, look, you need to make there be a financial consequence. You need to make there be a consequence for bringing an action that will discourage people from bringing these actions unless they're really serious. And if you don't have that, people are still going to file them because a cost award for someone who's very wealthy is going to be a relatively minor thing, and they'll still bring these actions. And so this section 5 is called no further steps. If you sue someone like this and they bring an application to say, you are interfering with my free expression, this is a matter of public importance, I want the court to determine this under section 4. Everything stops on other proceedings that the expression is related to you. So if you are Mr. Grant and you are making an application to put in, I'm using Mr. Grant as an example, he is from the Torstar case that I was talking about earlier. You want to put in a private golf course, you have an application for rezoning in front of the municipality, and the person was talking about that, in this case a reporter from the Toronto Star. If you want to sue that person for defamation and that reporter brings an application against you under this bill, everything stops in the rezoning hearing until this matter is resolved. And the reason for that is we want to encourage people to resolve these things really quickly on both sides. It's a lot of motivation to ensure it's resolved quickly. Secondly, that it's really serious, that the defamation is so serious that the person says, yes, hell yes, we'll put this, pardon me on parliamentary language, heck yes, we're going to put this thing on hold, and I want to sue this guy for saying that I was improperly interfering with politicians on this. And so it's a test really for a person to make sure that it's worth their while to go through with this. It increased the cost to go to court in a way that is more than just money to address the issues of of an inequality in resources. It's a significant section of the Act to draw members' attention to that. Section 6, this one says no amendments to the pleadings unless permitted. It sounds very technical, but the issue is you bring the lawsuit, you sue the guy, and successful in getting the lawsuit dismissed under this bill, and you say, no problem, I'll just slightly modify my claim, and I'll bring it back in front of the court again, or I'll seek leave to amend my pleadings to include something different, or to include something more. Now that I've lost, I'll just do it again, and then you're stuck in an endless cycle of going back and back and back and back on applications, and it achieves the same intent as if the whole thing went to a full trial, and it defeats the purpose of this bill. So this prevents you from going back to amend your pleadings or your documents that you filed to start the lawsuit in order to try to avoid an order to dismiss the proceeding. So you're not allowed to do that. That's captured by the bill. Section 7, costs. This creates an assumption. It's not, it allows the court to make a determination on this. But if the court makes a dismissal order and says, no, this is an interference with free expression, this is a problem, we're going to stop it, the person who asked the court to make that determination, the defendant usually, is entitled to costs on the application and in the proceeding, unless the court says that the assessment is inappropriate in the circumstance. So it gives the court a safety valve if they want to not give costs to someone for some reason that they behaved particularly badly or something like that. Section 8. You'll remember that one of the big differences between the 2001 bill and the bill that's in front of the House today is the need to prove the motive of somebody who has brought the lawsuit. 2001, you had to prove the motive, that they did it for a bad purpose. In this bill, you don't have to prove that. You just have to prove the impact on free expression. So that's a big difference between the two bills. But you'll see here in Section 8 that it talks about damages if the respondent brought the proceeding in bad faith or for an improper purpose. If you are able to prove, or if the court finds that the person sued you in bad faith or for an improper purpose, this allows the court to give damages to the person who was sued to say, you are entitled to some compensation for being dragged into court for a bad purpose or an improper purpose. Again, a recommendation of the Morin panel out of Ontario. Section 9 talks about the procedure on an application in one of these things. It's in accordance with the existing Supreme Court civil rules, subsection 1. The second is that an application for one of these dismissals can be made at any time in the action after it's been started. Once it's been made, it needs to be heard as quickly as possible. You remember from Morin, they said these need to be heard quickly as possible in order to minimize the financial impact on individuals. Evidence must be given by affidavit, and that's a sworn document. That's not testimony in court. It's a paper-based process. It still provides the ability for people to cross-examine on affidavits, but you're only allowed 7 hours max. There's a restriction on that. All in the name of getting this resolved as quickly as possible, whether the case can go on or whether it has to stop. And the court, again, is given the discretion to extend or limit cross-examination as necessary. Section 10, one of the problems is, you set this up and then someone appeals and appeals and appeals and appeals, and then the person's in court for years anyway, even though they've been successful in proving that this was an interference with their free expression. And so this section is simply a direction to the court that an appeal of a dismissal order under this act must be heard as soon as practicable. And this would be something that would be used by someone in court to say, look, they're engaging in delay tactics, they don't want to get in court on the appeal. It needs to be heard as soon as possible, and the court will step in and address that issue. We hope. Section 11, I would talk about a stay of administrative proceedings. This is a further detail about, pardon me, you know what, I conflated my sections. This is the section I was telling you about, that nothing goes ahead in relation to whatever the underlying project is or issue is that the person was speaking about, and nothing continues until this is resolved. The other section that I was talking about said you're not allowed to take any further steps in the litigation, so you can't sue someone for defamation, then they bring an application to have it dismissed, and then you keep going as if it didn't happen. Everything stops in the lawsuit as well. So everything comes to a stop once one of these applications is filed, and then all the rules say this needs to be dealt with as quickly as possible to ensure fairness to the plaintiff and ensure fairness to the defendant to get it resolved as quickly as possible. Section 12. It was not the intention of this bill to create any other rights or remedies or interfere with them, any other rights or remedies that might be available to people. So when Jeff Plant was talking about Rule 18 or 18A, or whether you're talking about the Supreme Court of Canada decisions where they might have given different rights to defendants or plaintiffs under defamation, this act is in addition to those. It's not meant to take away from any of those rights that might be available to either the plaintiff or the defendant. And Section 13, Offense Act, it's a fairly standard provision. A lot of acts simply to say the Offense Act doesn't apply here. We're not trying to create a provincial offense. And then finally, the coming into force date. And now, keep in mind, there's already a section that says that this is for cases filed on or after May 15th of last year. And the Act comes into force on the date of royal assent, so it can be made use of where appropriate as soon as possible. It won't come into effect by regulation because we believe there is some urgency in getting this legislation into place. So, Honourable Speaker, that brings to a close my remarks on the bill, the reason why we brought the bill, the text of the bill that's in front of the House, and some of the background in relation to the defamation tort traditionally and as it's evolved through the Supreme Court of Canada, and how we're not trying to displace that jurisprudence or those decisions of the court, the direction of the court. We're attempting to provide greater effect to it by provide a procedural remedy where people can have this considered by the court sooner rather than at the end of the trial, so they don't have to spend their life savings defending themselves in court in multiple years, that they can have it dealt with right off the bat. So with that, Honourable Speaker, I take my place. Thank you.